Welcome to the deep dive. Today, we're diving into something absolutely critical for you, the real estate professional. We want to give you that actionable knowledge, the kind that protects your clients and really sharpens your title expertise. And look, we're not just talking about basic deeds here. We're focused on easements. It's this really high-stakes interest in land that defines how property can be used, its value even, without actually owning it. Miss this. And, well, you could torpedo a whole transaction.
Yeah, the goal today is really to make this stick
Yeah.
because it's dense stuff but so important. So let's start simply. What is an easement?
Hmm.
Fundamentally, it's the legal right for someone who doesn't own a piece of land to use a specific part of it for a very specific purpose. And what purposes are we usually talking about? Mostly, it boils down to getting in and out. That's ingress and egress.
Oh.
Then utilities and, crucially, drainage. Especially here, Sarasota, Manatee County, the low-lying Florida areas. Drainage easements are often vital for development, flood control. Oh, and an interesting point, the person or company holding the easement right, they don't pay property taxes on that strip of land they're using.
That tax thing is, yeah, a side benefit. But for us, boots on the ground, the number one issue, the make or break factor, has got to be access. Ingress and egress, that dictates value almost immediately.
That's the absolute truth. And here's the rule. A buyer should always make their purchase contingent on having confirmed legal access to a public road. I mean, it's literally pre-printed in standard contracts like the Florida Realtors Florida bar forms for a reason. Its absence is just catastrophic.
Which means for you, our listener, if you're looking at a property and it doesn't touch a public, government-owned road, if it's landlocked, it needs a documented easement over whatever land is between it and the road. And if that piece of paper, that recorded easement, isn't there, the owner of that intervening land could illegally put up a fence tomorrow, no warning needed.
And poof.
Yeah, exactly. That property's value just plummets. It's essentially unusable. Which brings us to the survey, right? That's our first line of defense.
Absolutely critical. Before closing, the survey has to confirm one of two things. Either, one of the property boundaries lines up perfectly, exactly with the public road right-of-way, or the survey clearly shows a recorded legal easement connecting the property to that public road.
No gaps.
No gaps, no assumptions. If there's a gap between the property line and that road access, your client is in immediate legal jeopardy. Big trouble.
And easements aren't just for roads, are they? I mean, they can be a pretty creative fix for things like encroachments.
That's right. It's a good point. Say a neighbor's fence, or maybe the eaves of their roof, stick out a few feet over your client's property line.
Happens all the time.
It does. Now, selling that little sliver of land to the neighbor might seem easy, but it could actually violate zoning or building codes, maybe make your client's remaining spot too small.
Right, creating an illegal lot.
Exactly. So in that case, granting an easement can be the perfect solution. The neighbor gets the specific right to keep their fence or eaves where they are on your client's land, but your client keeps ownership. It avoids a potential teardown order, avoids the zoning fight, turns a potential war into a manageable agreement.
Okay, so we've really hammered home the access issue. If that's the big problem, let's get into the tools, the two main types of easements you'll encounter in deeds. Appurtenant and engross.
Right. Appurtenant easements are probably the most common ones you'll see, especially in residential deals. They benefit the land itself, the adjoining piece of property. Doesn't matter who owns it.
So they sort of stick to the land.
That's the phrase, yeah. They run with the land.
Yeah.
Meaning they automatically transfer to the new owner when the property is sold.
Even if, say, I sell my back lot and I forget to specifically mention the easement giving them access across my front lot in the new deed?
Technically, yes, it still transfers. But best practice is always mention it clearly in the deed. Avoids any confusion later. And this brings up some key terms you need to know. The property that benefits from the easement, your backlot, in that example, is called the dominant estate. My property, the one being crossed, the one burdened by the easement, that's the servient estate.
Dominant benefits, servient serves. Got it.
And crucially, if I sell my servient estate, the front lot, that easement still exists for your backlot's benefit. The sale doesn't wipe it out.
Okay, so that's appurtenant. What about the other type, easement and gross? How's that different?
An easement in gross benefits a specific person or a specific company, not a piece of land.
Ah, like the power company.
Exactly like the power company running lines across your property. Or maybe a pipeline company. The utility company is the beneficiary, not an adjacent landowner. So there's a servient estate, the land being crossed, but there's no dominant estate, no benefited parcel.
Okay.
And these are often used when the property owner wants the right to end when that specific person no longer needs it. Or if the company moves its lines, for instance. It's more personal, less tied to the land itself.
Right. Now, this is where things can get really tricky, legally speaking. A potential nightmare for a realtor if it's missed. Creating easements when land is divided. The deed drafting.
Oh, yes. This is a big one.
Picture this scenario. Someone owns a big piece of land. They decide to sell off the front part, the piece right next to the road, and they keep the back part, which is now landlocked.
Common situation.
The huge mistake we see is the deed for the front parcel says it's being sold subject to an easement for the benefit of the back parcel.
Right. And if you see that phrase subject to used like that, alarm bells. Big red flag should be going off.
Why? What's the problem?
Because Florida courts have consistently said that just saying a property is sold subject to an easement doesn't actually create the easement if it didn't already exist legally.
Right.
It's just acknowledging that one might exist somewhere else in the title history. If it wasn't properly created before that deed, the back parcel is still landlocked.
Wow. So that wording is critical. What should it say? If the owner is selling the front parcel first?
They must explicitly reserve back the easement in that deed. They are reserving the right-of-way across the land they are selling for the benefit of the land they are keeping. That difference, subject to versus reserve back, I mean, it's literally the difference between a valuable property and one that's practically worthless.
Or I guess the easier way is just sell the back parcel first.
That's often the cleaner way, yes.
Yeah.
Sell the back parcel first, and in that deed, state that it's being sold together with an easement for access over the front parcel that the seller is retaining. Always, always check the sequence of how the land was divided and the precise words used in those deeds.
Okay, super important takeaway there. Let's switch gears slightly. We know how they're created, hopefully correctly. How do people live with them day to day? Once you have, say, an appurtenant easement for access, what are the rules of the road, so to speak? What can the easement holder do? And what can the property owner do?
Okay, so the serving estate owner, the person whose land is being used, they can still use that easement area. It's still their property. But, and this is the key, they can't do anything that materially interferes with the easement holder's specific rights.
Materially interfere. Okay, so for an access road, can the property owner put up a fence, put up a gate? It is their land after all.
Generally, yes. Fences and gates are permissible. The owner still has the right to secure their property. But, and here's the catch, if it's an ingress and egress easement, that gate can't be an undue burden.
Undue burden, meaning?
Meaning it can't unreasonably hinder access, so a locked gate. Even if you give the easement holder a key, courts often say that's an undue burden because it slows them down, it's inconvenient, especially in an emergency. If you install a gate across an access easement, you'll likely need to install automatic openers that the easement holder can operate easily. Remote control, keypad, something like that.
Okay, that makes sense. What about the other side? What limits are on the easement holder, the person using the road?
Well, they can't increase the burden on the servient estate beyond what was originally intended or reasonably foreseeable when the easement was granted.
Right. So if the easement was created 50 years ago for access to a single farmhouse, the new owner can't suddenly decide to build a massive subdivision back there and expect to use that same little easement road for hundreds of cars, right? That's increasing the burden.
Precisely. That level of traffic, the change in the character of the use, likely goes way beyond the original intent. That's not allowed. Also, the easement holder can't let their neighbors start using the easement too. You can't just invite others to piggyback on your easement right if their property wasn't part of the original grant.
Good point. What about maintenance? If that gravel easement road needs grading or maybe paving or a culvert washes out, who pays?
Well, the right to maintain the easement is usually implied because, without maintenance, the right to use it becomes pretty worthless over time. But the financial responsibility, unless the easement agreement specifically says otherwise, the easement holder, the dominant estate owner, the one benefiting, is responsible for paying all the costs: construction, maintenance, repairs, all of it.
Wait, even if the servient estate owner, the person whose land it is, also uses the road sometimes?
Even then, the primary duty falls on the holder. The servient owner generally has no legal obligation to maintain the easement area or chip in for costs unless they've explicitly agreed to do so in writing.
That is a really crucial point for buyers to understand. They might be buying not just a property, but an ongoing road maintenance bill. Okay, quickly then, just touch on a couple of other characteristics.
Sure. Most easements we've discussed are affirmative easements that give the right to do something, like travel or run utility lines.
Yeah.
But you should also be aware of negative easements.
Negative.
They give the holder the right to prevent the serving owner from doing something on their own land. Think of things like easements for light, air, or view. Especially in, say, high-density areas or along the coast, somebody might pay a lot of money for a negative easement that stops their neighbor from building anything that would block their ocean view. These are valuable and therefore often very expensive.
Ah, interesting. Okay, now for the scenario every realtor dreads. You've got a client, they love a property, but turns out there's absolutely zero documented access. It's landlocked on paper. What happens then? You have to go to court.
Pretty much. If there's no written easement, your client has to file a lawsuit to try and establish an easement by operation of law. There are basically three ways this can happen. First is the common law way of necessity.
Common law way. Okay. What does that require?
Two main things. One, the property has to be genuinely landlocked. No reasonable or practical way to get to a public road. And two, crucially, you have to prove that at some point in the past, the landlocked parcel and a neighboring parcel that does have road access were owned by the same person, a common owner.
So you need that historical link.
Exactly. If you can prove both those things, landlocked status and prior common ownership, the court can grant an easement. And importantly, under the common law way, the landlocked owner usually does not have to pay the neighbor for the easement.
No payment needed. Okay. But what if you can't find that common owner? Maybe the records are old, unclear.
Right, that happens. Then you look at option two, the statutory way of necessity. This is based on a specific Florida law, section 704.012.
And how does that one work?
It also requires the landlocked status, but you don't need to prove prior common ownership. However, this statutory right is only available if the landlocked property is being used or is intended to be used for specific purposes, as a dwelling, for farming, ranching, or timber operation.
Okay, so it has use restrictions.
It does. And here's the other big difference. If you get an easement this way, under the statute, the owner of the servient estate, the neighbor whose land you need to cross must be compensated. You essentially have to buy the easement right from them at a price determined by the court if you can't agree.
Right, so common law is free if you qualify. Statutory you have to pay. What's the third way?
The third way is probably the most contentious. Prescriptive easements. This is like acquiring land by adverse possession, but instead of ownership, you're acquiring the right to use a part of someone else's land.
How does that happen?
It requires using a specific part of the neighbor's land, say a path or driveway, openly, continuously, and critically adversely, meaning without the owner's permission for a long period of time.
And how long is that in Florida?
20 years. Continuous, open, notorious adverse use for 20 full years. If your client can prove all that, a court can grant them a prescriptive easement. And like the common law way, the owner of the servient estate is not compensated. They lose that right without payment, which is why these cases are often fought tooth and nail.
20 years of using it without permission. Wow. Okay, so easements can be created in various ways, even by court order. How do they end? Can they be terminated?
Yes, they can. The simplest ways are, the easement holder just signs a written document releasing their rights, or both parties, the holder and the servient owner, sign an agreement to terminate it. Both should be recorded, of course.
Makes sense.
But there's also a more automatic way called the doctrine of merger.
Merger.
Yeah, merger happens when the same person ends up owning both the dominant estate and the servient estate. Think about it. You can't have an easement over your own property, right? It doesn't make sense. So the moment one owner holds title to both parcels, the easement automatically disappears. It merges into the main ownership.
And if they later sell one of the parcels off again?
They'd have to create a brand new easement from scratch, using the proper methods we discussed, like reserving it back. The old one doesn't just reappear.
Got it. Okay, so wrapping this all up for our listeners, the realtors out there, what's the big picture takeaway? Understanding easements isn't just about knowing definitions for a test. It's really about spotting hidden value, or maybe more often, hidden liability for your clients.
Exactly.
Knowing the difference between subject to and reserve back, knowing if your landlocked client might get a free easement versus having to pay for one. That kind of knowledge separates a really good agent, a truly valuable advisor, from someone just filling out forms.
It really does. And maybe a final thought to leave with everyone. Thinking about that prescriptive easement, the one you get after 20 years of hostile use. If your client owns property, the Servian estate, and sees a neighbor is starting to use a path across it without permission, what's the simplest thing your client can do today, a documented action, to absolutely prevent that neighbor from ever claiming a permanent free prescriptive easement, even 19 years and 364 days down the road?
That's a good one. Proactive thinking.
That's the kind of thinking that protects your client's property rights and value long term.
And that proactive, protective approach is exactly why having reliable legal support is so crucial when you're dealing with the complexities of title, access, and easements. It's key to getting those smooth, successful closings we all want. So for all you real estate professionals listening in Sarasota and Manatee County, we just want to remind you that Barnes Walker has been a trusted partner in real estate and legal matters here for, over 30 years now?
That's right, a long history supporting the community and the real estate industry.
Whether you need thorough title services to spot these issues early, or you need specialized legal help to actually create an easement, resolve an access problem, or just understand the implications for your client, they have the experience. They really are committed to guiding pros like you. You can reach out to Barnes Walker directly, give them a call at 941-778-7721, or you can also reach them at 941-867-7818. Make sure you've got that expert guidance in your corner for every single transaction. It can make all the difference.
That's all the time we have for this deep dive. Thanks for tuning in.